Oh, okay. Yeah, I understand that. Okay, well, we just need some paperwork here. We need to verify you're the trustee. We've looked at the document. You're the trustee. So, okay, no problem. We need your ID. We need you to fill out this form. We need letters testamentary from the probate court. Whoa, wait a minute. Letters testamentary from the probate court? I thought this wasn't in probate. Oh, well, technically it's not in probate, but we want this probate paperwork. Hi, Jeff Mersace, the Plain English Attorney, and welcome to the video. Today we are going to talk about 5 reasons why pay on death beneficiary designations are not good enough when you're working with a revocable living trust. Now, this seems to be really a more recent phenomenon with the volume of pushback that my clients are getting when they're going to a bank or another financial institution, and the recommendation is to move the ownership of the account into the trust. And they're starting to hear, oh, well, you can just make the trust the pay on death beneficiary, and that's good enough. Well, it's not. It's not. And here are the 5 big reasons why. Number 1, what if there's an incapacity? All right, if someone becomes incapacitated and that account isn't inside the revocable living trust, the trustee can't just go and say, hey, I'm the trustee, let me get control of this account. They're going to say, no, it's not in the trust. It's in their individual name. That's what a power of attorney is for. Okay, great. Part of what we put together when we do all the estate packages, if we're doing a revocable living trust, we are doing a power of attorney. But here's the big problem. This has been a trend over the recent years that even if you have an absolutely valid, legally executed, proper under state law power of attorney, the banks and the financial institutions can say, oh, we're not going to honor that. We have our own form, and since they never filled it out on our form, you're going to have to go to court and get a guardian or a conservator assigned. Okay, that means probate. It's called living probate. And it's accounting to a court and having to go through this process when, okay, no, if it was just inside the trust, the typical terms of the trust that we put together say all it takes is for 2 physicians to certify in writing that the trustee can't handle their job as trustee, and it goes to the next person. So that just makes it so much easier because it's already inside the trust. All right, what about the second reason? There's just so much you can do in terms of contingent beneficiaries. So if you're just trying to do contingent beneficiaries, so we're going to name the spouse as the beneficiary, then we're going to name these other beneficiaries. And okay, if you're doing it that way and you're just ignoring the trust, well, that's when you end up with, okay, well, what if it's supposed to go to the spouse? Oh, no, the spouse dies before you do. All right, I want it to go to the kids equally. What if one of the kids passes on? Oh, well, then I want it to go to their descendants. Okay, you can slap per stirpes on it. What if there are no descendants? What if it's just one kid and there's no descendants? Oh, I wanted it to go to my nephews. Well, no, we're going to throw it into probate because the nephews aren't listed as a 3rd-level contingent beneficiary. We only have room on the form for 2 slots. If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel. If it goes into the trust and the trust is the owner, all of those different contingencies are taken care of. There's no issue with, okay, we're falling down on not having contingent beneficiaries being limited because there's only so much space on the form. Now, here's a kind of related issue that if it's going to individuals, such as a grandchild because the parent passed on, suddenly you end up with no age limits. The trustee's not in control of it. So the trustee is supposed to be there to manage the assets and have it end up going to the beneficiaries. Now, these last 2, okay, admittedly, if you just name the trust as the beneficiary, all right, there's, it's not as much of a problem, but it still is a problem that it's not already in the trust. What is number 4? Okay, what if the deaths don't happen in the correct order or spread out far enough? I've seen this happen all the time. As an example, and I would give it out all the time, but this actually did happen. Okay, person passes on, their spouse is named as the beneficiary. They try to get control of the money, get the funds transferred over to them, but they die. Usually it's after 30 days, but before they actually collect the money. Oh, we're going to send it to that spouse's estate, meaning the spouse who was the pay on death beneficiary. They didn't live long enough to get the money. Okay, so now we end up with another problem in that it's going into probate, and it wouldn't have to if it was owned by the trust in the first place. All right. 5th big thing. And even if it was just number 1 and number 5, even if it's, we need to name the trust as the pay on death beneficiary, I am seeing more and more that they're still getting the court involved. Okay, it's supposed to be, if it's a pay on death beneficiary, it should go to the beneficiary, even if the beneficiary is the trust and the trustee comes forward. It's like, oh, okay, yeah, I understand that. Okay, well, we just need some paperwork here. We need to verify you're the trustee. We've looked at the document. You're the trustee. So, okay, no problem. We need your ID. We need you to fill out this form. We need letters testamentary from the probate court. Whoa, wait a minute. Letters testamentary from the probate court? I thought this wasn't in probate. Oh, well, technically it's not in probate, but we want this probate paperwork. Look, you can split hairs, and I've seen professionals do this, and it's the most ridiculous thing in the world to my clients and their families. Well, technically it's not part of probate because it's got a pay on death beneficiary. It doesn't end up in a certain part of the initial inventory schedule, and you don't have to pay any probate fees on it, but we just want the paperwork for it. Okay, if you got to go to a court, the probate court, everybody other than the professionals goes, well, that's in probate. The whole point of a revocable living trust is to not have to deal with the probate court for anything that is inside the trust. So it's not really serving our clients to just, well, we'll just do it as a pay on death beneficiary designation. All right, so what are the exceptions that are out there? And it is limited when you're talking about bank accounts and stock accounts and your after-tax dollars. If most of my clients, if it's, say they're a married couple, they've got one account, like a checking account usually, that they call their operating account. All right, that operating account has money that comes in and goes out each month. It's not like they're putting the bulk of their savings in there. And all right, if they pass on and that gets tied up in probate for a bit, or there's a delay because they want some extra pay, look, that's not a big deal. There's the access to all of the other money through a savings account or a money market account or the stock investments and things like that. So technically with the bank, they can't change the ownership on account. They open a new account in the name of the trust and move the funds, and you'd have to reset all of that money going in and out, all those automatic deposits and bill pay. Okay, that's a hassle. All right, so that becomes an exception, and we tell our clients you need to make sure you're solidified the power of attorney just in case. But for the money that's their savings accounts, the stuff that's putting money away, that definitely should be in the name of the trust. All right, what's another exception? When you're talking about retirement accounts, if you take a retirement account and move it into the name of the trust, that's as if you took all your money out in one shot, and now they want all the taxes are due or even penalties. and you've just kind of blown up your retirement plan and the whole tax deferred status. All right. In that case, there are a couple of different options. I talk about this in other videos, but you can, in that way, you're naming either the trust as the beneficiary. Usually it's the spouse first, or you've got other named beneficiaries if they're responsible enough. The tax advantages are outweighing the problems that could come with extra paperwork, so that's okay. And then the third big exception, I have never seen an issue with a life insurance company stating, oh, you need this probate paperwork. Or even, oh, this power of attorney isn't on our form, so we're not going to honor it. So, all right, when it comes to life insurance, naming the trust as the pay on death beneficiary ends up being okay, again, just because I haven't seen any problems with it. So, no, it is definitely not the same thing to just say, oh, well, we'll just make the trust the pay on death beneficiary. It's going to be fine. It might not be. So those are the 5 big reasons not to. We've got 3 exceptions, 2 of them small, 1 of them, it's a big tax one. So, okay, great. So I hope you found that information useful. As I always tell my clients, look, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.